This is Dr. David Shine, and welcome to Business Law 101. These are the 6 types of things, agreements that need to be in writing in order to be enforceable, in order for you to go to court. The first one is the one I love because it does, again, go back to feudal period when women were viewed as a burden. I've never understood this, but back then women were viewed as a burden. I find it fascinating because women did a lot of the work. They, harvested the crops. They, collected eggs from the chickens. They slaughtered the chickens they were going to eat. They milked the cows. I mean, the women in the household did an enormous amount, and yet they were viewed as a burden and not as a positive. So in a lot of cases, the farmer would say to the farmer next door, hey, if your son will marry my daughter, I'll give him 2 cows. Well, some of you can see where there could be lots of issues around such deals. And so it was determined agreements and contemplation of marriage must be in writing. And that also includes whether you can get an engagement ring back if the parties decide not to get married, by the way. I've never really understood the reason to pay a dowry, but in any event, in present day, as far as I know, we don't do that here in the United States. However, we do have something called a prenuptial agreement, and prenuptial agreements are required to be in writing under this same provision. Now, what's interesting is if you have a cohab agreement, which of course is not a marriage, it's just saying here's how we're going to camp out and be roommates, that is not required to be in writing because it is not in contemplation of marriage. So this is literally interpreted. This is Dr. David D. Shine for Business Law 101. If you've enjoyed this episode, please subscribe on your favorite platform.